Thank you, everyone. Please be seated. We have several cases before us today. In the matter of property seized for forfeiture from Shelby Cason is hereby submitted without oral argument. Our first oral argument of the day is LS Power Mid-Continent versus State of Iowa and others. Parties look like they're ready to go. It's my understanding Mr. Valencia and Mr. Dublinske will share time. Okay, I'll let you guys be the manager of time. You may begin.
Thank you, Madam Chief Justice, and may it please the court. Counsel. Good morning. Though this case implicates technical matters of state and federal regulation, the issues before this court today are not so complicated. The questions here boil down to simple questions about how an injunction is supposed to work. And the injunction here is overbroad, it's improperly retroactive, and it issued despite plaintiffs' failure to show the inadequacy of their other remedies at law. But I'd like to first start by addressing a theme central to plaintiffs' briefing in this case. Plaintiffs argue that where a court enjoins a statute as unconstitutional and enjoins it for all future projects, then it would be unfair for that same court to not grant them retroactive relief as to 5 specific already assigned projects. But nobody here is saying that plaintiffs don't get a remedy. They got a prospective remedy, and they just can't get a retroactive remedy here because they're either suing the wrong party or they're suing the right parties in the wrong forum.
Well, let me kind of back up. I mean, 30,000 foot, my general understanding, and I practiced law a long time before I became a judge, is that if somebody asks for an injunction, court denies it, you go up and appeal, you win, you get what you, to the extent possible, what you would have gotten from the trial court in the first place. So what's wrong with that?
I think the phrase you use, to the extent possible, does a lot of work there because the court's jurisdiction still matters. And the issue here is that the retroactive relief is either requires an action by a third party, which is MISO, or if it's enjoining anything that the commission is doing, the commission is agency action. The franchise proceedings here that are ongoing, if you're enjoining that franchise proceeding, that's agency action and that's exclusive under 17A. So to the extent possible is doing a lot of work. They could have gotten a remedy if they went and participated in the commission proceedings, and they could have either petitioned themselves for a franchise, they could have objected or intervened in the intervener power company's franchise proceedings. They chose not to do any of those things, and instead they sat on the sidelines. And I think the important thing here is to consider.
If the injunction isn't effective, why are you up here fighting it?
Because I think it's a matter of keeping this court's precedent straightforward and jurisprudential hygiene. Because
if this injunction is, what you're saying is this injunction, they've enjoined the wrong party, it's not effective, it's not going to do anything. MISO is the party they need to be enjoining. Then let's move on and let's let MISO decide what it should do.
Second, I'm not saying it's not effective. It is effective, but it's outside the court's equitable jurisdiction. Because what the court purported to do with the injunction, it says it was returning the parties to the status quo pre the right of first refusal statute. In order to do that, if I take a 30,000-foot view of the processes here that are required under the MISO and the IUC commission process, step 0 is where MISO says we need a project for our regional grid. So step 1, they look at who's going to wants these projects, and they assign those projects. MISO assigns the projects at step 1. Step 2 is when they.
With this, it might clarify something for me. If MISO were named as a party in this case, procedurally, what would have happened? Or what's your expectation of what would have happened? Does that become a federal issue at that point?
Into federal issues that the intervener power companies are going to talk about a little more closely, the federal preemption issues that apply to them. And MISO in their amicus brief talked about that, how this would creep into federal preemption. They had a remedy against MISO, and they've actually used it in other cases. So if you look at how they challenged the right of first refusal statute in Minnesota, they went to FERC. If you look how they challenged the right of first refusal statute in Indiana, they went to FERC. In New England, they went to FERC. They actually, in the Indiana case, just went to FERC in February while the appeal was pending there in the 7th Circuit with an issue of could the commission there have done anything to grant them relief as to that right of first refusal statute. So they know how to go to FERC. So that's their one adequate remedy at law. The second adequate remedy would have been to participate in the 17A proceedings here. And that gets back to my sort of laying out the steps here as a boiled down sort of 4-step process. Step 1, MISO awards the projects. Step 2 is where the commission comes in. Once you get that award of project from MISO, you come to the commission and you petition for a franchise. And the commission then goes through informational proceedings and perhaps a contested hearing. And that's then where the commission decides who gets the franchise. But if MISO hasn't approved it,
The statute wouldn't, as I understand it, didn't provide for that. The statute said if these two companies want to have the projects, they get those projects, and the competitors don't get to bid.
I think what this court talked about in LS Power 1, the harm that enjoining the statute would solve is the harm to let them take the playing field and compete. This injunction does not let them take the playing field and compete for these 5 specific projects, because nothing that a court can do here can change MISO's decision. And even if enjoining the commission or the power companies could let these LS Power take the playing field, it's outside the court's equitable jurisdiction, because this court has been clear from Salisbury Laboratories, Black v. University of Iowa, all the way since then, that the 17A remedies are exclusive. And what the
About we can't change MISO's assignment of the projects. Can you discuss the mitigation plan and whether maybe this is a moot issue now, or how does that implicate what we're doing here?
On our side of the V here, we think that MISO has clarified this in the variance analysis, and they've said, we recognize the district court's injunction doesn't allow us to proceed on a project that was granted under right of first refusal, and we've looked back at it, and now we're granting them this project outside of the right of first refusal. LS Power, of course, disputes that interpretation of the variance analysis, but I think a dispute over what the variance analysis means and what MISO has said belongs either in FERC, where you can tell FERC MISO is misinterpreting or misapplying its tariff. Or if you think the commission's doing something that's wrong and violates this injunction, you take your win with this injunction enjoining the statute prospectively, and you bring it to the commission, and you present these issues to the commission. And the commission could decide whether it was proceeding improperly, and then you could seek judicial review there. They had adequate remedies at law. They just sat on the sideline and chose not to take the playing field. And that's a key problem when you issue an injunction. One key factor is, was there adequate remedies at law? And the district court here didn't say there wasn't an adequate remedy at law for this as to 17A. If you look at...
It's usually for a temporary injunction, but not for a permanent one. If the statute's invalid, a permanent injunction doesn't generally require no adequate remedy at law.
Precedent says that, in Ray Langholz with permanent injunctions, that one of the factors is whether there's an adequate remedy at law. And so I think here that's the problem, is they had an adequate remedy, and if what the statute controls is a key moment in time, which is the assignment of the projects. IUC does not assign the projects, MISO does. And so to actually do what the district court said, which is return the parties to the status quo and let them take the playing field, you have to change MISO's decision. And even if the commission or the power companies can do something about it, if you can tell the commission or the power companies to sort of go pens up on the project, you have to do that through the proper jurisdictional forum. And here, a court in its original or equitable jurisdiction doesn't have authority to enjoin agency action. This court in Kerr and Juquette and other cases has said IUC's franchise proceedings are agency action. The court's injunction here says that it was going to, 17A did not strip it of its equitable authority to enjoin the 17A proceeding, because it said it would, quote, see no logic in requiring plaintiffs to undertake an extra expense or take more time to enjoin the judicial review. But there's no expensive exception to the 17A's exclusivity.
So as I understand, I mean, you're making some reasonable points, but let me see if I can play this out. What you're saying is that what LS Power should have done is, in the midst of while the appeal was sort of pending before us, the previous appeal, when the IUB was about to award those the tranche 1 contracts to the two companies under the first right of refusal, what they should have done was appear before the IUB and then raise the same arguments they were already raising in front of us.
Was after this LS Power 1 decision from this court on March 24th, 2023, they could have taken that decision on the merits of the constitutionality of the statute, even though it's preliminary, and gone to the commission and said, this statute's enjoined. and they could have participated in the 17A proceedings. They have a right to object, they have a right to intervene, and they also could have gone to FERC, and that's exactly what they've done.
Had already been awarded, right?
Active remedy, they might be able to get it from the commission or from FERC. They can't get one from this court.
Once we granted a temporary injunction, they should have figured out that really wasn't enough, and then they needed to go and appear before the IUB that are already awarded these projects?
Case in Tyndall v. Norman makes this point. You can make an anticipatory challenge of an agency statute, but you can't then take that anticipatory challenge and make it a 17A challenge that directly affects ongoing proceedings in the agency. That's what Tyndall says. So what they brought here originally was an anticipatory challenge of a statute, and then they should have taken that and then gone to the agency if they thought the agency was proceeding improperly. I see.
There's a pending proposed legislation that would apply retroactively back to 2020. If that's enacted, would that render this appeal moot?
I'm not sure if it would render it moot, and I think those issues could be hashed out if the bill does pass. It's still a bill. It hasn't passed either houses, and so I would hate to speculate here as to what a pending bill would do to this case about an already enjoined bill.
Pass for the 4 years in between. Would you agree that this statute, the challenge statute, once we held it was unconstitutionally enacted, was void ab initio?
The court has to reach the void ab initio question because it can assume that it was void ab initio, and the question is how do the parties get the remedy? And the remedy is not in a court of original or equitable jurisdiction. The remedy against the commission for ongoing agency action would be 17A. The remedy against MISO is FERC because FERC has exclusive jurisdiction there. But to the extent of whether something is void ab initio, I think that goes beyond this court's judicial power. It decides cases with the parties in front of it. Of course, parties can then take their win as to that prior case and assert it elsewhere. I see I've gone far over my time for my colleagues. I apologize. Thank you.
Thank you. Mr. Dublinske?
Thank you, Your Honors. May it please the court. I'm going to throw out the plan here at this point on the clock, and I just want to jump right into address some of the points that Justice Mansfield was making. The interveners certainly don't disagree with the state about the retroactive problem with this injunction, the overbreadth of the injunction. Specifically, that in this case causes a problem of stepping over the line between state jurisdiction and exclusive federal jurisdiction. I don't disagree with my colleague that it could have been raised at the Utilities Commission, but Your Honor, the easiest way for this to have been addressed properly would be to have raised the problems with how the state ROFR was adopted at the end of session in a bill that the title didn't reflect the ROFR, what was up here before the court previously in the state court. But as soon as MISO made its assignment, that challenge has to be in the federal system. Specifically, it has to be to FERC. It's important to note, and I think is clear, how much this case has changed since we were last here in 2022. At that point,
Have any towers been erected on these Tranche 1 projects? How far along is construction?
that's a little more complicated than you might think because of the upgrade issue, right? So there are no actual new towers built on Tranche 1, again, because of all the pending litigation, because waiting for the variance analysis, but there are significant portions that will be upgrades of existing facilities. So there are some pieces that are in place.
Let me ask,
Yep.
in terms of,
If we look at one period that might be relevant, from our perspective, would be if we take October 2022, which is, I understand, when your client and the other company exercised the right of first refusal, and March 2023, when we entered the injunction, what happened in that 5-month period? Was there anything significant that happened in that period? Because that might be the period, if you're talking about retroactivity, that might be, once we're after March 2023, it seems to me there's a good argument it's not retroactive anymore.
Your Honor, I think the key date is July 2022, when MISO actually made their assignments. So what the MISO tariff in Section 8...
But your client didn't exercise until October, isn't that right?
We had 90 days to claim, and that's an important distinction, for example, between this and the NextEra case out of Texas, that case notes is that here there's actually an opportunity for people other than incumbents to get in if during the 90 days we don't claim. So we think the actual assignment was made in July, and we could have foregone it.
Happened between July and July 2022 or October 22 and March of 2023? What actually, was done by at least by your client? You can answer for that.
At that point, it was largely planning, right? So there's a couple things that have to happen. You've got to, develop a route so then you can submit to the Utilities Commission for an informational meeting, which is the kickoff of that process. Not much more than that would have happened in a long lead time process, but the assignment was already made at that point. Your Honor, I see I'm out of time. If I can just have a couple of seconds here to finish. Your Honor, I want to reiterate that LS Power, despite our argument that it isn't retroactive, still has a significant remedy that absent further action by the legislature or to change in MISO tariff, still would be eligible for tranche 2.1, which has already been announced, and future tranches. The ROFR has been stricken as unconstitutionally adopted, but the injunction purporting to reach tranche 1 is...
Hypothetically, if tranche 2 is issued and given exclusively to your client and disregarding our opinion, is the exclusive remedy only still with FERC?
If there is no ROFR, right, so the legislature does nothing new, the MISO tariff doesn't change, all the legal framework is as it is today, and they announce the assignments for 2.1 and they give it exclusively to the incumbents, the remedy for that is at FERC. Right, the MISO decision under its federal tariff is challengeable only at FERC.
I have a follow-up. So the variance analysis mitigation plan, as I understand it, MISO took the steps of looking at the injunction and saying, regardless of the right of first refusal, we're making this assignment because a certain percentage of the upgrades are already going to be done by the incumbents and all of these other things. So they've already reassigned it. Correct. So what impact does that have here if MISO's complied? Even though they're not a party, they've effectively complied with the injunction and reassigned it.
Correct, Your Honor, and I think it's important to note that variance analysis, because LS Power argues that MISO is ignoring the Iowa court's orders, which is simply not the case. The variance analysis only happens because they acknowledge that the ROFR has been stricken. They look at other portions of their tariff and say, what happens if there's a threat to the ability to finish the project? And they note that under the transmission owner agreements, the default is that if it touches somebody's existing facilities, that owner gets to build it. That's Section 9 of the tariff. Competitive processes are in Section 8 of the tariffs, different tariff rules.
Doesn't FERC itself recognize our court's role in all this when they recognized an abandoned plant incentive?
I don't believe so, Your Honor. We talk about that in our brief, that we have an opportunity to protect ratepayers and stakeholders from financial loss. Nowhere in there do they say that MISO's tariff is invalid or that MISO has a way around the tariff. And so we believe that that is a separate issue that is not dispositive on any issue before this court. Yep.
What I read in the briefs about MISO is, I'm not a utilities lawyer. I think I know something about antitrust, but I'm not a utilities lawyer. And, when I see MISO has, preemptive authority and doesn't, and Mr. Reck will probably argue they don't have preemptive authority, why don't we do what we're supposed to do under state law? And if, in fact, FERC and MISO preempt us, and you are allowed to go ahead anyway, that's okay. I mean, they'll tell us. What's wrong with that approach?
First of all, I would argue that they have told all of us in the variance analysis that the incumbents are still expected to go forward with these projects. But where we sit today, we have a conflict preemption problem that creates a certain jeopardy for my client, for Mid-American Energy, for the incumbents, in that we have a federal entity under federal tariff saying, we expect you to go forward with these projects that remain assigned to you. We have a district court order that says you're enjoined. Now, we happen to think that the terms of that injunction have been satisfied. To Justice McDonald's question, which I took to mean, is there a potential mootness here? And I think perhaps that's true, but as we just saw below, LS Power continues to file, for example, motions to enforce. And while it was denied without prejudice. And this will continue to be a litigated issue unless there's some finality on it, right? Our position is the variance analysis gives you sort of two options. One, it lays out the fact that the federal side has in fact taken a position that is not dependent on the ROFR, and the appeal for that, if LS Power wants to stop those projects from going forward, has to be at FERC. The alternative option the court has is to look at the injunction below and say, everybody obeyed it, it's been satisfied, we're done. But I think one of those options, either the overturning of the 7th and 8th ordering clause, or simply verifying that it has been satisfied and the litigation needs to stop, the projects need to go forward in the interest of the customer's reliability and to avoid further delay. I think one of those two things is the right response in this case. Happy to answer any other questions, but thank you.
Chief Justice, Justices, may it please the court, counsel. I'm Mike Reck with co-counsel Chris Jessen on behalf of LS Power and Southwest Transmission. Thank you for your time here today and for the second time. We do appreciate it. And the issues are, as has been stated to you, important. It goes to the power of this court to enforce our state's constitution. There is nobody else that does that. There are two things that are beyond dispute at this point in this case. One, on June 14th, 2020, our state legislature violated our state constitution. It violated Article 3, Section 29 by forsaking the transparency that's required and the accountability that's required in how we pass legislation. Two, as this court already held, my clients were harmed by that act. The question becomes, is there a remedy and who is to impose that remedy? There is no other entity anywhere other than this court that can override the legislature to enforce the law. There are two remaining questions. The main ones are answered. One, when parties choose to proceed knowing that an injunction has been sought, that a statute has been challenged as unconstitutional, when they forge ahead, is this court somehow rendered powerless to address the harm that results? Because that's what they argue. There can be no retroactivity, as they say, even though this was challenged from day one. And two, as I've already alluded to, who gets to interpret and enforce the Constitution of the state of Iowa? The state and interveners argue if you act fast enough, you forge ahead, darn the torpedoes, full speed ahead. We know it's challenged. Frankly, I don't think it was that hard a constitutional issue. They know it wasn't in the title. They know that bill had numerous different parts. Go fast enough, you get to keep the projects. That, Your Honors.
Argument, Mr. Reck, that you could have and didn't also proceed in front of the IUB, especially once you had a ruling, or at least a provisional ruling from our court that this was a unconstitutional statute.
Versus Norman mentioned a moment ago, that case actually favors LS Power. And that case says it is unnecessary when the underlying act has been struck down under Article 3, Section 29 to then go through the administrative process. What is the IUC going to say at that point? The Supreme Court got it wrong and we get to proceed? That would be a needless venture, and that's what this court held in Tyndall, that there was no need to do so. The IUC did not have the power that we needed, that our clients needed to strike down this law. That is solely within this court.
Remedies with FERC that you have not pursued?
To that would be no. And the answer is because of Great Lakes Gas Transmission Limited, 843 F3rd 325. State law issues are not FERC issues. FERC will actually forego looking at state law issues. If you look at Portland General Electric, 72 FERC paragraph 61009, That is not within their special expertise. They do not have more expertise in Iowa's Constitution than this court does. They have no expertise. Further, if you look at order number 1000, the one that said there will be no more federal ROFRs, as we've called these, it says that this is a state law issue. We are going to leave it to the states to address. You are the highest judicial authority in this state, not FERC.
Going forward, that the interveners decide they've looked at the variance analysis, the mitigation plan, and they are going to go forward with all the work on tranche 1 beyond just the upgrades, which I think everybody agrees they're entitled to do regardless under federal law. What happens next? How would you block them from doing that, so to speak?
Built into that. One, I would say that if you look at the analysis that came down from FERC, what they said is because the ROFR was in effect at the time, we are going to leave it in effect. I don't think it's nearly as clear that they said anything about these being upgrades. I think they did very definitely say that the ROFR is what decides this. In terms of the response to your question, the district court held that we had to seek contempt. I don't believe that's right. I think you can seek to enforce an order without reaching that elevated standard of beyond a reasonable doubt and showing malice. But we absolutely have the ability to.
Let's assume you proceed with contempt or you proceed with an enforcement action in the district court. Doesn't the legal analysis of whether or not they're violating the injunction ultimately depend on an interpretation of FERC's mitigation plan, which makes this a FERC issue and not a state law issue? I don't see how, I think you just said it in your answer. Well, you know, we read the mitigation plan to say we recognize the right of first refusal, et cetera. I don't see how you uncouple that ultimately at the end of the day.
Say to you is rather than this court interpreting what MISO is doing, MISO is interpreting what this court held and what the district court held. And that is not MISO's role at all. MISO is a member organization. It is not FERC. In fact, MISO routinely is at odds with FERC on ROFRs. I think we had a string cite of maybe 8 or 9 cases. MISO clearly likes ROFRs a whole lot more than FERC does. And so MISO is allowing this to go forward. FERC, and in fact, the DOJ recently came out and said again, federal law does not favor ROFRs. So when MISO says it does, that is not enforcing federal law.
But that's their decision. And so if they've told us in the mitigation plan, we read the order, we've gone through our federal tariff, and as we interpreted it, we're going to reassign the work to the exact same incumbents. Maybe that's to advance their belief that ROFRs are good. That still makes it a FERC question, doesn't it?
So if you look at Great Lakes Gas Transmission LTD, that actually was interpreting a tariff, all right? But they were state law issues within the tariff. And because they were state law issues, the 8th Circuit Court of Appeals said, no, 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 that is not a federal issue. That remains a state issue. And it is indeed alarming to me as a lawyer that MISO, as a member organization, would look at an order that says point blank, you may not proceed in any way that relies on a ROFR, and MISO said, we don't have to follow what the court said. We cited the Messina case, which I think is a Michigan District Court case, and it makes a very clear point that even agencies don't have the power to disregard state courts. That's not within their power, and MISO assuredly is not an agency. I'm sorry, Your Honor.
These Tranche 1 projects simply be returned for open bidding. Why can't that happen now?
In terms of the variance analysis, they keep saying that Ellis Power got what it asked for when it got a variance analysis. No, what Ellis Power said is there was the power to open these up for bidding, to respect this court's order through the variance analysis. They can absolutely do that. They have chosen not to, and that's why I say it's alarming. They are not doing what this court said, and they are assuredly not doing what the district court said. And we do not, by the way, have an amicus brief from FERC. All we have is the Department of Justice saying, no, we don't think ROFRs should be the law of the land, and they are not federal law. So they are applying state law.
On our decision to see what happens in the legislature with this pending bill that purports to retroactively invalidate all or validate all this?
See what happens when there is delay, right? The interveners routinely say, well, we've proceeded too far down the road. You can't stop us now. And so, no, that is alarming to us, and it does disrespect this court's role. If the legislature does do that, and to your point, they have not in the intervening 4 years, but if they do that now, then there will be different issues. Obviously, we will have what we've called the equal protection challenge at that point, should that happen. I doubt this is going away either way. But no, the legal issues remain extremely important. Who decides state constitutional law? And that is this court. They say that injunctions can't be retroactive. Well, first of all, there's been an injunction in place since we last visited with you. This court entered an injunction. And the words are clear. Blocking the ROFR's enforcement would allow LSP to take the field. It is plain to see a favorable decision will redress that injury. They insert the word not twice. Blocking a ROFR's enforcement would not allow LSP to take the field. A favorable decision will not redress that injury. Well, heaven forbid that courts can't redress violations of the state constitution. If not you, then who? Not FERC. When the state exacted an unconstitutional scheme, it must afford meaningful relief. That is the Hagee decision, 504 Northwest 2nd 448. But perhaps more important, the Cragness decision. The Cragness decision did say meaningful backward-looking relief is especially appropriate to rectify constitutional violations.
Distinguish that. So that's just a refund of money, but here we've got these construction projects that are somewhat far along, although I guess no tower's been erected on the.
No spade of dirt has been turned. And I apologize, I can't remember which one of you asked that question. But no, they're not particularly far along. They'd like them to be far along, and they claimed them while this case was pending. And indeed, that
Case where there was an improper bidding procedure and the court says, do it over, start over, and this time have fair competition.
is agencies are routinely enjoined to redo the bidding process in order to vindicate the disappointed bidder's right to a legally valid procurement process. That is the D.C. Circuit Court of Appeals, 963 F. 2nd 420. Yes, absolutely, that happens all the time. To argue that it cannot be retroactive simply is not accurate.
Cases, the decision maker is also a party to the case, right? I mean, so you're asking somebody, or you're asking us to order somebody who's not a party to this case to undo a process and redo it. I guess, why aren't they a party here, and doesn't that distinguish those cases?
Back to the beginning of the case, right? Why would we have sued MISO? And I will try to answer the question, right? But why would we sue MISO? Because the legislature acted unconstitutionally. It's an enactment of a bill. MISO had not done anything. But then two very important parties intervened. Mid-American and ITC, you do have them before the court, and they do have an obligation to respect Iowa law. And even if MISO will not, they must. And I guess I would use the basic analogy from employment law, right? We run across situations where an employee wishes to violate a covenant not to compete. And the court says, no, you have a covenant not to compete. You are hereby enjoined. But let's say a company up in Minnesota says, well, we interpret your order, justices, differently than you do. And we think we can proceed because we think it's okay. Do you lose power to tell that employee no? And the answer is, of course, you do not. You do have these parties before this court, and they have an obligation to respect this court.
Compete cases, I mean, you do see this in non-competes and securities litigation. I mean, you can sue the employee for breach of the non-compete, but you can't enjoin the competitor unless they're a party before the court. And it seems like what you want to do here is effectively enjoin the employee with the intent of kind of blocking the future employer without having them before the court.
Standing, I would have had to pursue MISO at the outset in this case. And in the hypothetical that you and I are pursuing, the employment law one, which maybe comes naturally to us, if the employer had not hired that person at the outset, there would be no basis to sue them, right? But when it comes up and the employee tries to go to work for them, certainly this court does have power over that employee, just as it has power over Mid-American.
The analogy
be, yeah, because I do think there might be something to this analogy. You're saying that like in a securities case, because I did some of those, where the broker leaves to go to another brokerage firm, if you represent the brokerage firm that they left, you enjoin your employee from going to work at that competitor, and the other brokerage firm says, well, we're not bound, we don't care, we're going ahead. That doesn't deprive you of jurisdiction to enjoin the employee. And then the other brokerage firm can figure out what it's going to do.
Absolutely. And there's been much made of the recent Seventh Circuit Court of Appeals decision, and it held that there was not standing because the MISO was out there. But in that case, there was no permanent injunction. In fact, they expressly distinguished this case.
Law metaphor. So let's keep playing this out then. And if you enjoin the employee, and the employee is enjoined and nothing happens, so are you saying in this case, what you want is the rebidding done? So you want the non-enjoined party to take some action when we don't have jurisdiction over that party. We cannot order MISO to do the rebidding because they're not before the court.
I agree with the second part, that at this point it is hard to issue an order. However, there is an order in place that says these projects, these Iowa projects, these projects that go before the IUC may not proceed unless they are issued in some way not relying on the ROFR.
An impasse then at that point. So the interveners are enjoined from doing work. We can't order MISO to do the rebidding. Then what?
Chairman's point, then MISO has a choice. If it does wish to proceed with these projects, this happened in Texas, by the way. And in that case, they actually said, these projects are no longer all that important to us and we're not going to proceed. They could do that, right? And you do not have to order them to have bidding. They could choose not to proceed with these projects. But if they wish to proceed with these projects, I hope it goes beyond dispute that they should follow Iowa law. Remember, ROFRs are an issue of Iowa law. Article 3, Section 29 is an issue of Iowa law. This court is the arbiter of Iowa law. And if Mid-American and ITC have a higher authority in MISO, that is news to me, right? MISO is a member organization of which they are a member. This court, and this is a lofty case. This is an exceptionally important case. It is the power of the courts to enforce our Constitution and say, you will follow it. And MISO, you can say whatever you want about the interpretation of this, but you're a member organization and we're the Supreme Court. It is exceptionally important. And I understand all the challenges that you're talking about, but they are before the court. And if MISO chooses to thumb its nose at the state of Iowa and its laws and says, well, we're taking our toys and going home and we're not going to rebid it, that's a choice they can make. But what they can't do is tell them they can violate the Constitution and violate an injunction. That is well beyond their power. Chief Justice, I've gone well beyond my time. I had one momentary thing that I was going to say.
Beyond two.
There was a case in terms of delay, and that's I'm going to quote Hamlet, which you all know means that I must be reading from a case because I'm not that well read. But Hamlet summarized the 7 burdens of man and put the law's delay 5th on his list. Justice delayed is justice denied, and regardless of the antiquity of the problem and the difficulties it presents, the courts and the bar must do everything possible to solve it. This was challenged immediately as a violation of the Constitution. Those lofty words are not mine, of course. They are this Supreme Court in Department of General Services, 336 Northwest 2nd at 408. Other lofty words, the Constitution is the palladium of Republican freedom. The young people, it actually said men, but I think that's a little sexist, coming forward upon the stage of political action must be educated to venerate it. Those already upon the stage must be taught to obey it. Whatever interest may be advanced or may suffer, whoever or whatever may be voted up or voted down, no sacrilegious hand must be laid upon the Constitution. Again, those are the words of this court in Kohler versus Hill, 15 Northwest, 630 to 631. These are lofty principles. I go back to the beginning. 2 things are clear. The Constitution was violated and my clients were injured. Do they have a remedy? Thank you.
Thank you, Your Honor. Constitutional principles are indeed lofty things, and while the state constitution is important and was fundamental to the first order in this case, there's also the U.S. Constitution to keep in mind and the Supremacy Clause. The problem here, and LS Power knows it because they've gone to FERC repeatedly. I disagree with LS Power that the question is who interprets the state constitution. That was the issue in case one. The only issue left is who interprets the MISO tariff. Even if you get into the void ab initio issue, inevitably the question, and inevitably the claim LS Power is making, is that MISO is somehow misinterpreting or misapplying its own tariff in the face of that state decision. But that issue is a MISO issue, and the only place they can get relief for that, as I think the Seventh Circuit case we submitted as supplemental authority is pretty clear, as MISO's own brief, and their tariff has the force of federal regulation, makes clear. I think LS Power gave the game up when my colleague talked about, well, you know, MISO could just decide to not have these projects. And that is in fact where we are. I strongly disagree with LS Power that MISO could rebid these. If you look in the MISO tariff at section 9, G, or 9E3 on reassignment, which is in the appendix at 667, 668, the language and the terms of that tariff make very clear that A, the variance analysis is how you get around a problem like this, and the options on a variance analysis allow you to reassign a project from a competitive bidding winner to an incumbent, but not the other way. This court may disagree whether that's a good idea, whether that's a good term to have in the tariff, but that is the tariff that FERC has approved, and state courts simply have no authority to require MISO to change its tariff, to ignore its tariff. In some ways, this is an extremely simple run-of-the-mill filed tariff doctrine case, right? At this point, any change required would have to go to FERC, and there has in fact been delay on LS Power's part in seeking that remedy. So this justice delayed is justice denied reflects their own litigation choices. To not bring in MISO when they knew that's who they really needed to stop from the assignment, to challenge the tariff, to challenge the assignment. All of those are MISO issues. They didn't name MISO, they didn't go to a jurisdiction that had an ability to enforce against MISO. Go ahead.
Kind of address the employment analogy that we were doing. What if the intervener said to MISO, I'm sorry, I'm subject to this injunction, I can't accept this project the way it's been bid? What happens then?
The fundamental difference between the employment cases and this case here, and really most of these cases that LS Power is using as an example, is that the third party that's affected is subject to state law, right? So the court has jurisdiction over everybody that can be affected for the relief that's being sought. As the Seventh Circuit points out, because the utilities commissions really are just filing repositories, you can't get full relief without MISO. But here you've got a bright line, right? You have the U.S. Supreme Court saying in the Federal Power Commission case that we cite in the brief that we meant to draw a bright line, easily ascertained between state and federal government, and unless it's been expressly delegated to the state, it's on the federal side where it involves transmission. So here, the problem is you can't reach across that line. And that distinguishes this from other cases. Also, the filed tariff doctrine distinguishes this from other cases.
Back to my original question, you know, if nothing can be done, why do you care? Why do you care what we do?
We're subject to jeopardy if we're found in contempt simply because we're following MISO's orders, right? We have this impasse, this conflict preemption problem where the state court is telling us, arguably, certainly LS Power thinks one thing, we think differently, telling us thou shalt not, and we have the federal agency telling us thou shalt.
And preemption won't allow that. That's a situation that cannot exist. Why don't we enforce Iowa law as we understand it, as we've been doing in this case, and then FERC can resolve if we don't have authority to stop and force a rebidding of the project. What's wrong with that? I mean, that's what I don't understand. You're asking us to, conclude on our own that there's this conflict preemption without, again, with the same point applies to you, without the parties in front of us that you say would demand conflict preemption.
Our position on that is you do have supervisory authority over the order entered by the lower court, and that was the order that created the conflict preemption. What we're asking is for you to take our clients out of this potential jeopardy and simply say, yes, you can enjoin going forward, but you can't create a conflict with federal law because, as you just acknowledged, that would be clearly preempted.
Why do we need to guess on federal law that we don't, like I said earlier, I'm not an expert on. Why don't we just enforce our law? And if we're wrong, obviously we will find that out.
I think there are a couple of answers to that. One is sort of an efficiency issue that I expect we would be right back up here if we just tried to move forward, right? Ellis Power just moved to enforce below. I think we'd have that chain happen again.
You can go to FERC and say, MISO has awarded us the project. Nothing that the Iowa Supreme Court can do can change that. There's a file tariff. You can make your preemption argument there, and they maybe can contest it, but they're not here. We're now in a position where we have to trust you on an area that I'll tell you I don't know a lot about. I mean, I feel very comfortable about my understanding of Iowa law, I think, but as we get away from that, I'm a lot less comfortable.
Respectfully, I'm not sure I agree that you don't have expertise on federal preemption, but I think it's the jeopardy problem, right? It's that Ellis Power is unlikely to just say, yeah, you're right. They've chosen not to go to FERC, which is where they have gone in other states and should go. When we sought reconsideration of the original order, they dropped a footnote saying, why don't you clarify this covers tranche one? The court correctly chose not to do that. But now we're in a situation where my clients have to have this risk of going forward. The other risk, of course, is that MISO just throws its hands up and said, look, we can't rebid. All we can do is cancel. That's bad for everybody. That's bad for reliability. It's bad for rates in terms of the delay. The projects will only get more expensive. That would be a bad public policy outcome, Your Honor. And I think the correct thing to do here is either to say the variance analysis solves it, which gets us out of the problem, or simply to say the lower court can't engage in a retroactive injunction because it violates the federal regime established by MISO's tariff.
Honor the injunction in Iowa law by saying the injunction says what it says, but the variance analysis solves it. That allows your clients to proceed with work. And if our interpretation of the variance analysis is wrong, then you guys can go have fun at FERC and litigate that issue and let FERC decide what the variance analysis says, right? So everybody wins.
Thing you technically could do that nobody's talked about is a primary jurisdiction referral, but the two obvious things are either to strike ordering clauses 7 and 8, or just simply to say, look, we gave you all a supplemental briefing to address the variance analysis. We've looked at it. We think the variance analysis meets the terms of the injunction. Done. I think either of those would be a proper outcome here. And I apologize. I meant to leave time for the state, but thank you for your additional time.
Actually, I think, Justice McDonald, did you have a question of the state anyway?
No, but Mr. Valencia looked ready to talk, so I thought we should at least give him a chance.
Your Honor, thank you. I'll be quick as I possibly can. One thing I failed to mention up front is that part of the injunction applies to the rules, the agency's rules, and the rules were repealed as of March 26th. So that issue is now moot, and I apologize for not mentioning that up front. My second point is my friends on their side have talked about, well, there was a constitutional right, there's a violation, we get a remedy. And again, I return to my first point. You still have to seek the remedy in the right forum. They invoked Marbury v. Madison in their brief, but Marbury didn't get a remedy from the Supreme Court because it was the wrong forum. And that's what's happening here is they have a remedy as to the commission. They can go participate in the commission proceedings. They've been able to do that under Iowa law. They have the right to object or intervene. They could have filed a petition, and they chose not to. The harm...
Iowa Utility Commission order MISO to reopen bidding.
I actually don't know if the commission can order MISO to do that because MISO's, it would be a question of MISO's interpretation of its tariff. I think what the commission can, what Alice Power can do would have participated in the commission proceedings, raise the questions they want to raise here that they say that this court has to have the power to interpret, and then it would have eventually got up to this court about is the commission acting in furtherance of the right of first refusal statute. And if the commission proceeding on these 5 specific projects that were previously awarded, if that's in furtherance of the right of first refusal statute, then this court would get to decide that through the 17A judicial review procedures. So there was a mechanism, and I don't hear them disputing that.
Likely a dead end and would take a long time.
Then, because I think the question of whether those 5 projects were awarded under the right of first refusal statute still is a question that the agency could have expertise on, and we go to agencies for their expertise, and then it would go up through judicial review, eventually probably to this court. And on the second point about take a lot of time and expense, that's not an exception to the 17A exclusivity. 17A is exclusive, and they could have gotten a stay of the franchise proceedings through 17A.19 sub 5. They could have stayed everything, and then we would have been pens up because of a 17A stay. They chose not to seek those remedies.
The last word on the Iowa Constitution, we held that the challenge statute was unconstitutionally enacted. If we now decide that it was void ab initio, isn't the Iowa Utility Commission bound by that?
That would be an issue that the parties could have presented to the Iowa Utilities Commission. And so I think the Iowa Utilities Commission is bound by this court's interpretation of state constitutional law. And so then if they were proceeding contrary to this court's decision, then somebody could intervene or object and raise that point to the commission if they think the commission is acting improperly. And then if the commission says, no, we think that the variance analysis solves this or something like that, then that could have been brought up on judicial review. They had this remedy. I don't hear them disputing that they had that remedy. They just didn't want to take it, and in their brief, they said it took too much time or expensive. The district court at page 17 of the summary judgment order said that it didn't see logic in requiring them to take on this additional expense. But this court's, in Black versus University of Iowa and a lot of other cases, says they, quote, maintain the integrity of 17A's judicial review procedures. And that's what we're asking for here. And so that's why it matters what this court says today, not just rubber stamping an injunction that may or may not have effect, because it's a matter of jurisprudential hygiene. This is a precedent this court would set, and later parties could then rely on it to enjoin agency action through this court's original or equitable jurisdiction. But this court should not allow that.
Variance ruling, it basically concluded the ROFR hadn't been struck down yet, so we're going to continue to honor it even after it's been struck down. And you're telling us our court can't do anything about that.
With the proper jurisdiction. So that Alice Power or somebody could present that issue to IUC and say, this is our interpretation of the variance analysis. Or it could be presented to FERC, obviously. But to get up through this court, you go to the agency with the expertise. They could interpret that, and maybe presented with that argument, they could have changed their mind. If they didn't, then that could have gone up on judicial review, and then this court would get to decide it. But they're basically trying to shoehorn all their possible remedies, prospective, retroactive, all future projects, 5 specific projects, to this into this specific case.
Saying, in essence,
I'm going to give you some more time, okay? So we've got a lot going on up here.
You're saying that, as I understand what you're saying, it is that this court, the state of Iowa, does have authority to stop or force potentially a rebidding of the projects, or at least somebody in Iowa does. It would, but you're saying it would be the IUC and not our court. As I understand the other argument from Mr. Dublinske, he's saying nobody here has that authority except for MISO and FERC. Is that right? Is there a difference between the two of you, Appellees? Appellants, excuse me.
In their premise that the commission could do this. And I'm saying, even if they're right that the commission can do this, you've got to go to the commission and present that. I think there is serious issues with the federal preemption and that these should be in FERC. But even if they're right, and even if you are right that this court should get to decide it, it can, just through the proper mechanism. And I think that gets to my last point, which is my friends on the other side cited this DC Circuit case, O'Donnell. They've cited Cragness. They've cited all kinds of cases like Olinson and Lysenko. The difference with those cases, though, is those cases were brought against the ultimate decision maker. And so you could seek an injunction to make that decision maker change their decision because they're a party before the court. Here, the decision maker was MISO. To the extent, to follow up on my point, that the decision maker is the commission, you still have to follow 17A's exclusivity because we have to maintain the integrity of Chapter 17A's procedures. Thank you.
And I got to get in control of this courtroom. 4 minutes for you, 2 minutes for you, hard stops. 4 minutes, timer.
Never in my 60 years on this planet has anybody ever asked to hear me speak more. So I thank you for...
Take advantage of this opportunity.
But I can't help myself now. Thank you very much. I will address very briefly this preemption notion. Preemption, when all else fails, let's go back to the root of the law, right? Preemption, we are guided by the fundamental tenet of preemption doctrine that federal law will not preempt state law absent a clear statement of congressional intent to occupy the field, or unless applying state law would conflict with or otherwise frustrate a federal regulatory scheme. That's this Supreme Court in the Reck case, 648 Northwest 2nd at 137. It has always been the law that siting and construction and all those sorts of issues on power are reserved for the states, not federal law. And that's what this is. How do we know that that's what this is? We know because Mid-American and ITC say so. If we look at the appendix pages 650 to 656, when they claimed these projects, they didn't say it was for any reason that it was an upgrade or anything else. When they claimed these projects, they said Mid-American Energy Company, ITC Midwest, and Cedar Falls Utilities, pursuant to Iowa Code Section 478.163, which has been struck down, and 199 IAC 11.143, respectfully submit this notice of intent to construct, own, and maintain transmission lines to the Iowa Utilities Board. That is what they did. They pursued this under an Iowa law, which has been deemed by our judicial system to be unconstitutional, and it was for constructing, owning, and maintaining transmission lines.
Mr. Valencia's point, and I noticed this as well. Page 34 of your brief, you have a string cite to a bunch of cases that apply injunctive relief, kind of retrospectively. But he makes the point that in each of those cases, the decision maker was a party to the case. And that is not true here. And that seems to me, and I've asked you kind of different ways, that seems to be a real fundamental problem, at least for me.
Decision was challenged, I guess is where I would start. And I know I have a hard stop here. What we were challenging was the legislature's unconstitutional act. That was never anything that MISO could decide. It was never anything that FERC could decide. That was always an issue that this court had to decide. The fact that MISO, after the fact, after an injunction is entered, says, we don't have to follow what the court said, that's just not how it works. And they could not have been a party prior to that time. And there was a final...
MISO in at some point?
Your Honor, they did this after there was a final order. So I guess I don't think so, is the short answer. I don't think I have a right to go back to the district court and say, we're going to now bring MISO in. In addition, it remains a state law issue, and I still have these parties before the court. They have been told they can't do this. They want to follow somebody else's guidance and not this court's guidance. That's just not how it works for our Constitution. You are the highest authority. I will touch very briefly, and I think I addressed it before in my last 33 seconds. Tyndall versus Norman expressly held at pages 872 to 873 regulations pursuant to an unconstitutional act that's unconstitutional under Article 3, Section 29. The regulations fall when the act falls. To suggest that we have to go back to the agency and say the Supreme Court said it's unconstitutional, but now please follow the Supreme Court, you already, the judicial system has already struck this down. I am right at my time. Again, thank you very much for your time and patience here today.
All right, thank you. We'll have 2 minutes with a hard stop for, it looks like, Mr. Dublinske, unless you're going to go share it.
I'm not going to try and share 2 minutes, but thank you, Your Honor. I agree with one thing that my colleague, Mr. Reck, said, and that was that you have a conflict where state law frustrates a federal scheme. That is exactly the preemption situation we find ourselves in. MISO has this integrated portfolio of projects that it has assigned. The suggestion that MISO somehow is not following this court's order is simply mischaracterizing the case. This court struck down the ROFR law. That will be true going forward. While void ab initio is a powerful legal constructive doctrine, it does not, in fact, change the fabric of space and time. The ROFR law was valid when MISO did what its tariff said, which was before assigning, we look and see if there's a ROFR. They did. At that point, that decision has been made, and it's no different than saying, look, there's a law that says every New Year's we're going to celebrate by going and sinking somebody's boat out in the Sailorville Marina. And this court later says, well, that was a ridiculous law. That's void ab initio. Those boats don't magically come back to the surface, right? The MISO tariff then kicks in, strictly a matter of federal process, and says what happens next, what can happen next, and what can't happen next is that they go back and competitively bid. Competitive bids have to be let in RFPs within 365 days. LS Power told you that themselves multiple times when they said, as of July of 2022, there would be irreparable harm. And they were correct as a matter of federal law in that. Again, not to take anything away from the state constitution, but there are two players here. They want to have you ignore federal law, federal constitutional supremacy throughout all of this. I'll leave you with a thought experiment, because when LS Power argues that the state law is what trumps here, think about this. If Iowa had a ROFR law, but either Order 1000 hadn't preserved state ROFRs or the MISO tariff didn't acknowledge them, would that law have any effect? The answer is no.
This is finally submitted. LS Power is hereby taken by the court. We are going to have just a pause here. We'll allow the next case to get situated while we take a brief break, and we'll be right back in the courtroom. Next case is Robinson.